Welcome back to the Deep Dive. Today we're looking at something pretty fascinating, actually. It's a legal idea that's centuries old, Doli Incapax. And it's really shaking things up now in child protection law right here in New South Wales.
Yeah, it's having a huge impact.
So we're going deep into this recent government review about the criminal age of responsibility. Now, the minimum age a kid can be charged here is 10.
Right.
But this Doli Incapax thing, it literally means incapable of evil. It can apply all the way up to age 14. We want to unpack what the review found and really why it matters.
And, you know, the people who led this review carry some serious weight. We're talking former Supreme Court Judge Geoffrey Bellew SC and former NSW Police Deputy Commissioner Jeffrey Loy.
Right, not lightweights.
Definitely not. And their job was basically to look at this old standard and ask, is it still right for today?
And what do they land on?
Well, the core finding is pretty striking. They're saying this ancient idea shouldn't just stick around. It should actually be put into law, become statute.
Into the actual legislation?
Yeah, exactly. They want the requirement that prosecutors have to prove a child understood right from wrong when they did something to be officially codified, written down as law.
Okay, so taking this protective shield that already exists in common law and making it permanent legislative, why is that step, codifying it, so significant for them?
Well, I think it really comes down to making it more durable. You know, common law evolves through judges' decisions.
Right, it can change over time.
It can. Theoretically, future court rulings could sort of chip away at it. But if you put it into statute, into the legislation itself, that locks it in much more firmly.
So it's harder to weaken later.
Much harder. It becomes the clear intention of the parliament, not just a judicial principle. It sends a strong message.
Okay, that makes sense. So let's get practical. This Doli Incapax,
Yeah.
it applies to kids aged 10 to 14. What does a prosecutor actually have to show to get past that presumption that the child is incapable of evil?
Yeah, and this is crucial. It's a really high bar. Before 2016, there was maybe a bit of fuzziness around it, but then a major high court ruling in 2016 really nailed it down. It clarified the standard significantly. It's not enough just to show the kid knew what they did was naughty or against the rules.
So okay, say a 12-year-old shoplifts a chocolate bar. They probably know that's bad, like breaking a school rule is bad, but the law needs more.
Exactly that. The 2016 ruling says prosecutors have to prove, and beyond a reasonable doubt, remember that the child understood they were doing something seriously wrong in a moral sense.
Seriously wrong.
Yeah.
Morally, that's the key phrase.
That's the absolute key. It's the difference, say, between that 12-year-old knowing they shouldn't spray paint a wall because, you know, it's vandalism and they'll get in trouble,
right,
versus understanding that destroying someone's property is fundamentally wrong, a serious moral harm to the owner and the community. The law now demands proof of that deeper kind of moral grasp of wrongfulness.
And that clarification, that shift from just naughty to seriously wrong, that's where things really started to change. The sources point to some big consequences from that ruling. We've got data from Bocsar, the NSW Bureau of Crime Statistics.
Yeah, the Bocsar data is incredible on this. It really tells the story.
What does it show? It's
stunning, actually. Before that stricter standard really took hold, prosecution rates for kids aged 10 to 13 were really high. We're talking 76% in the 2015-16 financial year.
76%. So 3 out of 4 kids charged were actually being prosecuted.
Yeah, moving through the whole court process.
Okay, then the ruling beds down. Prosecutors have to meet this higher standard.
And the numbers just plummet. That prosecution rate fell off a cliff down to only 16% by 2022-23.
16%, wow.
Yeah.
From 76 down to 16.
It's a massive shift, and it seems to be driven almost entirely by clarifying how this one legal principle, Doli Incapax, should be applied. It really shows the power of this safeguard in practice.
That huge drop, 76 to 16, I mean, that sounds like a massive success from a child protection perspective. But I guess when prosecution numbers fall that much, it causes political waves. Is that why some groups wanted this standard looked at?
Oh, absolutely. You hit the nail on the head. You see pushback from groups like the State Nationals and some community safely advocates, and it comes from a genuine place, a concern.
What's the concern?
Well, when prosecution rates drop so steeply, the perception for some people is that it's soft on crime. They worry that kids who commit offenses are just being let go without consequences, or maybe more importantly, without getting the support they need to change their behavior.
Right. The intervention gap.
Exactly. And that perception, that worry, created the political pressure for this review in the first place.
Which brings us back to the review's main choice. They could have just said, okay, let's raise the minimum age of criminal responsibility to 14, like many groups wanted.
That was definitely an option on the table.
But instead, they went for this sort of middle path. Keep the age at 10, but double down on the Doli Incapax safeguard. Make it law. Why did Bellew and Loy go that way?
It seems like a kind of legal and maybe political balancing act. They openly acknowledged the current test, the seriously wrong test, imposes a high threshold. They didn't shy away from that.
But they defended it.
Strongly.
Right.
They called it an important safeguard against the possibility of inappropriate findings of criminal responsibility. Their focus seems to be really on protecting the child from a potentially devastating wrongful conviction.
Okay.
They specifically mentioned the considerable vulnerability of kids this age, 10 to 13, and the, quote, significant impact upon such children of a criminal conviction. And that's huge, right? Getting a criminal record at 12 or 13 can basically derail your entire future. Jobs, education, even just traveling overseas.
Yeah, the lifelong consequences.
Exactly. So this safeguard acknowledges that the cost of getting it wrong, of labeling a vulnerable child as a criminal inappropriately, is just too high.
So, by putting Doli Incapax into law, they're essentially locking in that super high bar for prosecution, making it only possible in really clear-cut cases where that moral understanding can be proven,
Right.
while still keeping the idea of criminal responsibility on the books for community safety reasons.
Precisely. And they also made a point of trying to separate this specific age group, 10 to 13, from the wider, often more heated discussion about youth crime generally.
Oh, so?
The report emphasized that only a, quote, small proportion of kids in the 10 to 13 bracket are involved in serious or persistent offending. They warn against conflating these very young children with, say, issues involving older teenagers.
Okay, that makes sense.
Yeah.
And that focus on the vulnerability of this younger group seems to lead directly into the review's other major focus, which is intervention, right?
Yeah.
If most aren't being prosecuted, what do we do?
Yes, that's the flip side of the coin. They clearly recognize that the big drop in prosecutions created a potential gap. What happens to these kids now?
So what do they recommend?
The focus is heavily on non-criminal justice pathways, things aimed at support and rehabilitation, not punishment. This includes stuff like voluntary referrals to support services, specialized assessments to understand the child's conduct and needs, and tailored support plans, especially for kids with complex issues.
And they mentioned therapeutic court orders. What does that actually involve for a child who's done something wrong but isn't deemed criminally responsible?
Right. So a therapeutic court order is basically a way to use the court's authority, but for supportive ends. Instead of punishment, the court would order the child into specific programs or services.
Like what sort of things?
Could be mental health treatment, drug and alcohol counseling, help with housing, connecting with disability services, that sort of thing. It's about addressing the underlying reasons for the behavior, using the court order to make sure the child and family actually engage with the help they need.
Now, when we talk about any of this intervention, the justice system, we absolutely have to talk about disproportionality. Bocsar's data, Aboriginal legal groups, they all consistently point out that Aboriginal kids, and also kids in regional and remote areas, are way overrepresented.
It's a critical piece of context, and any reform, especially around intervention, has to grapple with that reality.
So how does that feed into the reactions to this review? Because not everyone agreed with the recommendations, did they?
No, definitely not universal agreement. And that issue of disproportionality is central to the different viewpoints. Take the Aboriginal Legal Service, the ALS. They welcome the report for confirming the high Doli Incapax standard.
Nope.
But their CEO, Carly Warner, argued it doesn't go far enough. The ALS position is actually to raise the minimum age of criminal responsibility to 14 and get rid of Doli Incapax altogether for that age group.
So they don't want the high hurdle. They want no criminal pathway at all before 14. Why such a strong stance?
It comes down to evidence about systemic harm. Warner pointed to research showing that locking up kids, any contact with the criminal system at that age, actually makes them more likely to reoffend later on as teenagers or adults.
So backphrase.
That's the argument, that it increases future crime and perpetuates cycles of trauma, especially for Indigenous communities. So for the ALS, the goal is zero contact with the criminal justice system before age 14. Keep it purely in the welfare and health space.
Okay, so that's one clear perspective. How does that contrast with, say, the NSW Attorney General Michael Doli? He seemed focused on that intervention gap you mentioned earlier.
Yeah, the Attorney General's comments really highlighted that gap. He said the current situation are not operating in the best interests of children or the broader community, precisely because kids might fall through the cracks if they're not prosecuted. He stressed, and I'm quoting loosely here, that we don't want kids left without intervention only to end up back in court later because they didn't get the support to change. So his focus really backs up the need for those therapeutic pathways the review recommended.
And then there was another angle. From the Council for Civil Liberties, they seemed to question the whole review process itself.
That's right. Timothy Roberts, their president, basically asked whether the government should even be debating how to prosecute 10-year-olds. His point was, should kids, that young, year 4 or 5 primary school kids, be facing criminal charges at all?
So similar end goal to the ALS, just perhaps a different emphasis.
Essentially, yeah. He argued pretty simply that having less young children in prison is a good thing, pushing the focus back onto just raising the age outright.
It really lays bare the core tension, doesn't it? On one hand, you have the approach of confirming this really strong legal shield, Doli Incapax, at age 10, making prosecution very difficult but still possible. And on the other hand, the push to just raise the age to 14, take the criminal system out of the picture entirely for that group, and relies solely on welfare and health responses.
Exactly. And the review, led by Bellew and Loy, tried to navigate that. They opted for what they see as a balanced approach. Make the powerful legal safeguard official law, but at the same time, build up these non-criminal therapeutic pathways to catch the kids who need help and ensure community safety is addressed through support, not just punishment.
So if we pull it all together, the massive drop in prosecutions after 2016, from 76% down to 16%, really shows that the high, seriously wrong standard works in practice to protect kids.
Yeah, that drop is kind of the proof of concept for Doli Incapax.
And the Bellew review essentially says, let's lock that success into law, make it permanent, and crucially build the support systems around it so vulnerability is addressed and behavior can be changed without resorting to criminal conviction in most cases.
That seems to be the goal. That huge drop in prosecution sets the benchmark, really. Any new laws or pathways will need to make sure they maintain that level of protection for these vulnerable 10 to 13-year-olds.
Okay, so that brings us towards the end. But let's leave our listeners with something to think about, drawing from everything we've discussed.
All right. Well, given that everyone acknowledges the huge overrepresentation of Aboriginal children in the system, the final question has to be this. How can this proposed new legal framework, and especially these new therapeutic pathways, be designed and implemented to actively address those deep-seated systemic inequalities? It can't just be about tweaking the legal definition of criminal intent. How do we make sure that the support, the intervention, actually reaches the kids who are most disproportionately affected and works effectively for them and their communities? That feels like the next critical challenge.